When contact with your child is suddenly blocked, every day can start to feel like the new normal. Getting advice early can stop one painful moment from turning into a harder fight. In England and Wales, the court is not there to reward whoever argues hardest. Its focus is your child's welfare, and every decision comes back to what best supports them. That usually includes protecting a meaningful relationship with both parents, as long as that contact is safe and genuinely right for the child. Under Section 1 of the Children Act 1989, the court puts your child's welfare first. It also treats delay as harmful, because drawn-out conflict can make a child's situation worse. The judge also starts from what's called the no-order principle. That means an order is made only when it would help your child more than leaving things as they are. To work that out, the court looks at a checklist that includes your child's wishes and feelings, their needs, any likely change in circumstances, any harm, and each parent's ability to meet those needs. When emotions are running high, it's tempting to push back, turn up unannounced, or fire off angry messages. But moves like that can inflame the situation and leave you looking less focused on your child and more focused on the fight. What the court wants to see is a child-centered response, one that keeps your child's safety, routine, and sense of stability at the heart of every step you take. A lot of contact disputes can be settled without a hearing, through calmer steps like constructive messages, direct negotiation, or mediation that helps both parents focus on workable arrangements for the child. Before you make a C-100 application, you'll usually need to attend a mediation information and assessment meeting called a MEAM, unless your case falls within a recognized exemption. Once the C-100 is filed, that usually starts the private law case. Before the first hearing, CAFCAS will normally carry out safeguarding checks, so any immediate welfare concerns are flagged early. The first hearing, called the FHDRA, is often listed around week 5 or 6. That hearing is there to narrow the issues, see what can be agreed, and map out what needs to happen next. If the court needs a fuller picture, it may order a Section 7 welfare report. And if one parent raises allegations of harm that the other disputes, the court may need a fact-finding hearing before moving on. Parents can apply as of right. Grandparents and other relatives often need the court's permission first before the case can move ahead. If the case gets that far, the court can shape the arrangement in practical ways, including where a child lives, when time is spent together, whether contact is direct or indirect, and any supervision or conditions needed to keep it safe and workable. If domestic abuse or other harm is alleged, the court does not treat contact as automatic. It has to examine the risk carefully and only order contact if your child's safety and the safety of everyone involved can be protected before, during, and after that contact. And if the case keeps being dragged back to court in a way that causes distress or keeps the conflict alive, the judge can make a Section 9114 order. That can restrict repeated applications so the litigation itself does not become another source of harm. Getting advice early helps you work out the right route for your situation. Whether that means enforcing an order that already exists, asking the court to vary it, or making a fresh application because the facts have changed. That kind of guidance at the start can cut delay, lower the temperature between parents, and keep the case centered on what matters most, your child's welfare. If contact is broken down, speak to Dominic Levant solicitors for calm, confidential advice that helps you protect your relationship with your child. Visit DominicLevant.com to understand your options and take the next step with confidence.